Have you ever sat in a room and watched someone you once called family look a judge in the eye and lie, not stumble, not hesitate, but lie with the kind of confidence that only comes from practice? I have. I sat in that courtroom in Austin, Texas, with my hands folded in my lap, and I counted the ceiling tiles above the jury box. 12. I counted them 3 times just to keep myself from reacting. Because my sister-in-law, Renee, was standing at that podium describing me as a woman who couldn't manage her own emotions, let alone a financial estate, and every single person my mother had ever loved was sitting behind her, nodding. My name is not important. What matters is that my mother spent 31 years building something from nothing, and when she died, someone was already waiting with a pen. My mother, Carol, raised my brother Marcus and me in a 2-bedroom house in Cedar Park, just outside Austin. She worked as a paralegal for 22 years. She was the kind of woman who kept paper copies of everything, who laminated her insurance cards, who once drove 40 minutes back to a restaurant because she thought she might have left a receipt on the table. She was meticulous. She was careful. And she loved us in that quiet, steady way that you don't fully understand until it's gone. Marcus is 6 years older than me. He was always the one who got the phone calls first, the one who drove her to appointments when I was still finishing my degree. I never resented that. What I didn't see, until it was almost too late, was what happened in those quiet hours between the two of them, and more specifically, between my mother and the woman Marcus married 3 years ago. Renee was charming in the way that certain people are charming when they need something. She remembered birthdays. She brought my mother herbal tea when she was tired. She called her mom before Marcus even proposed. And my mother, who had been lonely in a way she never said out loud, opened the door. I noticed small things. The way Renee would steer conversations about money toward herself, the way she began showing up at my mother's house on weekday afternoons when I was at work, the way my mother once started to tell me something on the phone and then stopped and said, "Never mind, it's nothing." I filed those moments away. I didn't know yet what they added up to. My mother was diagnosed with early-stage Parkinson's in the spring of 2 years ago. She told me on a Tuesday afternoon, sitting at her kitchen table with a cup of coffee that had gone cold. She was calm about it. She said she had already spoken to her attorney and updated her will. She said everything was taken care of. I asked if I could see the documents, and she said yes, of course. And then Renee walked in through the back door with groceries, and the conversation ended. I didn't push. I told myself I was being respectful of her autonomy. What I was actually doing was being naive. My mother passed away 14 months later. She was 63 years old. The Parkinson's had progressed faster than anyone expected, and in those final months, she was in and out of clarity in a way that broke something in me I haven't been able to name since. 2 weeks after the funeral, Marcus called me. He said we needed to talk about the estate. I drove to his house expecting to sit at a table with documents and divide things the way our mother had planned. Instead, Renee handed me a single sheet of paper across the kitchen counter like she was passing me a menu. It was a summary. Not the will itself, a summary, typed up on plain paper, unsigned, with no attorney letterhead. According to this summary, my mother had revised her will 8 months before she died. The house, the savings account, the small investment portfolio she had built over 20 years, all of it transferred to Marcus as sole beneficiary. I was listed for personal items and a symbolic amount. I asked to see the actual will. Marcus said his attorney had it. I asked for the attorney's name. Renee said they'd send it to me. I drove home, and I sat in my car in my own driveway for a long time. I am a forensic accountant. I have spent 7 years reconstructing financial records for litigation cases. I know what a last-minute document revision looks like. I know what pressure on a signature looks like. I know what a frightened, deteriorating woman with limited mobility and a daughter who worked full-time and a daughter-in-law who was always there, I know what that combination can produce. I did not call Marcus back that night. I called my own attorney. Her name is Patricia, and she has the kind of stillness that makes opposing counsel nervous. She listened to everything I said without interrupting. When I finished, she asked me one question. "Do you have any documents in your mother's handwriting from before the diagnosis?" I did. I had birthday cards. I had a handwritten recipe my mother had mailed me the previous Christmas, written on an index card in her neat looping cursive. I had a letter she had written me when I graduated from college, 2 full pages, folded into an envelope that still smelled faintly like her kitchen. Patricia told me not to contact Marcus or Renee about the will again. She told me to gather everything I had and sit tight. I sat tight for 4 months. 4 months of watching my brother post photos on social media of renovations to my mother's house. New kitchen counters. A refinished deck. The bedroom my mother had kept as a sewing room, emptied out, and painted gray. I watched all of it from a distance, and I did not say a single word. What I did do was work. Patricia had requested a copy of the filed will through the probate court, which is public record, something Renee apparently did not know. The will had been executed 8 months before my mother's death, just as the summary claimed. It was signed by my mother, witnessed by 2 people, and notarized. On paper, it looked clean, but I am a forensic accountant, and my mother laminated her insurance cards. I reached out to her original estate attorney, a man named Gerald, who had drafted her previous will 11 years earlier. He was retired, but he remembered my mother clearly. He told me that she had contacted his office approximately 10 months before her death to discuss her estate and had seemed, in his words, entirely herself. He had referred her to a colleague when she mentioned wanting to make changes because he was no longer taking new estate work. That colleague's name was not on any document I had been shown. The notary on the revised will was a woman named Shelley. I found her through the state notary database. Patricia sent a formal inquiry. What came back was interesting. Shelley worked out of a UPS store location in Round Rock. Her notary log, which Patricia obtained through discovery once we filed a contest, showed that she had notarized the will on a Thursday afternoon. My mother's medical records, which I had requested as next of kin, showed that on that same Thursday afternoon, my mother had a scheduled physical therapy appointment 12 miles in the opposite direction that she attended. The appointment lasted 90 minutes. The sign-in sheet had her signature. She could not have been in 2 places. I need to tell you what I felt when Patricia called me with that information, because it wasn't triumph. It wasn't even relief. It was something colder and sadder, because it meant that someone had sat down and planned this. Someone had chosen a date, found a notary, and signed my mother's name, or convinced someone else to while my mother was doing her physical therapy exercises 12 miles away. Someone had looked at a sick woman and seen a transaction. I already knew who, but I needed the rest of it. Patricia filed the will contest in the Travis County Probate Court. Marcus retained an attorney immediately, a man named Douglas, who wore very good suits and spoke in complete paragraphs. Renee retained her own attorney separately, which told me something. When spouses in a unified position lawyer up separately, it means they've already started calculating who gets blamed. The weeks before the hearing were quiet on the surface and furious underneath. Renee called me once. I let it go to voicemail. She said she hoped we could resolve this like family. She said our mother would have wanted peace. I saved the voicemail and sent it to Patricia. Marcus texted me. He said I was making things up because I was grieving and not thinking clearly. He said he was worried about me. He said Renee had only ever tried to help our family. I read the text twice. I did not respond. I forwarded it to Patricia. I want to tell you about the morning of the hearing because I have thought about it many times since. I woke up at 5:30. I made coffee. I sat at my kitchen table and looked at a photograph of my mother that I keep on the windowsill taken about 4 years ago, before any of this, at a restaurant in downtown Austin on her birthday. She is laughing at something just outside the frame. She looks completely like herself. I said, out loud, to the photograph, "I've got it, Mom. I've got all of it." Then I put on my blazer and I drove to the courthouse. The hearing room was smaller than I expected. Marcus and Renee sat at the table to my left, Marcus in a dark suit, Renee in a navy dress that I recognized as new. She looked composed. She had prepared for a performance. The judge assigned to the case was the Honorable Judge Okafor. She was in her late 50s, wore reading glasses on a chain around her neck, and had the particular quality of someone who has heard every version of every story and is no longer moved by delivery, only by evidence. Douglas opened by arguing that the will was validly executed, that my mother had been of sound mind, and that my challenge was motivated by disappointment rather than fact. He was smooth. He used the word clarity 7 times. He spoke about my mother's relationship with Marcus and Renee, with a warmth that would have been touching if I hadn't known he'd met them approximately 6 weeks ago. My mother's name, in his mouth, sounded like a prop. Patricia stood up. She did not use warmth. She used the notary log, the physical therapy sign-in sheet, the appointment records, the mileage calculation, and a statement from the physical therapist who remembered my mother from that Thursday because they had talked about a television show they both watched. She laid each document on the table in front of Judge Okafor one at a time. The room got very quiet. Douglas objected 3 times. Judge Okafor overruled him twice and sustained once on a technicality that didn't matter. Renee's attorney said almost nothing. Then Patricia said, "Your Honor, I'd like to enter into evidence a comparative handwriting analysis conducted by a certified forensic document examiner. The signature on the revised will, according to the examiner's report, was inconsistent with my mother's verified signatures in 14 measurable ways. The pressure distribution was wrong. The letter spacing in her last name was wrong. The way she always looped the tail of her lowercase y, a habit so consistent across 30 years of documents that the examiner described it as a signature fingerprint, was absent. Judge Okafor removed her glasses from her chain and held them in her hand. She looked at the report for a long time. Then she looked up at Renee. She didn't look at Douglas. She didn't look at Marcus. She looked directly at Renee. "Ma'am," she said, "I have some questions for you." I will not pretend that what followed was cinematic. It was slow and precise and uncomfortable in the way that truth often is when it's finally in the right room. Renee answered questions in a voice that had lost its composure entirely. She said she hadn't known about the notary discrepancy. She said she had assumed the attorney handled everything. She said she had only been trying to carry out what my mother wanted. Judge Okafor asked her what my mother wanted. Renee said she believed my mother wanted Marcus to be taken care of. Judge Okafor asked if my mother had ever said that to her directly. The pause before Renee's answer was 11 seconds long. I counted. She said, "Not in those exact words." The judge set her glasses down on the bench. She looked at the documents in front of her for a moment that felt much longer than it was. Then she ruled. The revised will was invalidated. The prior will, drafted 11 years earlier by Gerald and held on file with the court, was reinstated. Under that document, the estate was divided equally between Marcus and me. She also referred the matter to the Travis County District Attorney's Office for review of potential document fraud. Marcus did not look at me when we left the courtroom. He walked out ahead of his attorney with his jaw set and his eyes on the floor. I don't know what he knew and what he was kept from knowing, and I find that I can't spend too much time on that question without losing something I need to keep. Renee looked at me once, on the steps outside. Just once, for about half a second. Then she looked away. I stood on those courthouse steps in the October sun, and I thought about my mother driving back 40 minutes for a receipt. I thought about the index card with the recipe chicken and white beans, the one I make every fall now. I thought about her handwriting, her lowercase y with its long curling tail, identified and documented and entered into evidence in a Travis County courtroom because she had been consistent and careful her entire life, and that consistency had outlasted everything they tried to do to it. The estate took another 7 months to fully settle. The house was sold. The proceeds were divided. I don't live in Austin anymore. I took a position in Nashville, and I've been here almost a year now. There are things about that time that I am still working through, and I imagine I will be for a while. But I want to say one more thing, because I've thought about how to say it for a long time. If you are in a situation where someone is telling you that you are confused or emotional or not thinking clearly, and your instinct is telling you something different, document everything. Every date, every conversation, every signature. Keep the birthday cards, keep the letters, keep the index cards with the recipes. Keep the things that show who someone was when they were entirely themselves, because those things have weight. Those things can walk into a courtroom and stand on their own. My mother was meticulous. She was careful, and in the end, she saved herself. She just needed me to find it.